A property developer in England spent £2.3 million buying land to build houses. He had planning permission, architects, construction crews ready, everything approved. Then, a retired woman walked into the council office with a photocopy of an 800-year-old document. Project cancelled. Money gone. Now here's why this matters to you. This law affects 1.2 million acres across England and Wales, land that people think they own. But here's the twist. There's no central register, no complete map, no way to know for certain if your property sits on common land. Until you try to build something. So how does a law from the year 1217 still have the power to stop modern construction? Why hasn't Parliament just removed it? And most importantly, what happens when ancient rights collide with modern property ownership? The answer reveals something fascinating about how the past refuses to let go. This is the King's Ghost Laws. Today's case, the ghost of common land. To understand this ghost law, we need to go back. Not to 1217 yet. First, we need to understand what common land actually means. Imagine England in the Middle Ages. Most land was owned by lords, by the church, or by the king. But here's the crucial detail. Ownership wasn't simple. Just because a lord owned the land didn't mean he could do whatever he wanted with it. The people living in the area, the commoners, had legal rights to use that land. These were called rights of common. The right to graze your cattle, the right to collect firewood, the right to gather food, the right to draw water. These weren't privileges, they weren't favors. They were legal rights, enforceable, protected. Because without access to common land, medieval peasants literally couldn't survive. Your few sheep needed somewhere to graze. Your family needed firewood to survive the winter. You needed access to streams and ponds. So the system worked like this. The lord owned the land, but the community had permanent, legally protected rights to use it. This wasn't written down in individual contracts. It was customary law, community understanding, rights that had existed since time immemorial, a legal phrase meaning so old that nobody remembers when it started. And here's where our ghost is born. Those rights, they never expired. Centuries passed, the medieval system collapsed, the Industrial Revolution happened. Modern property law developed. But those ancient rights to common land? Still there, still legally valid, still haunting the modern world. The year is 1217. King Henry III is on the throne. He's only 10 years old. England is recovering from civil war, and the country's powerful barons are forcing the young king to confirm legal protections for their rights. One of these protections becomes law. It's called the Charter of the Forest, and it does something revolutionary for its time. It legally protects common land and the rights that go with it. The charter states that common lands and the rights associated with them are permanent. They cannot be taken away without consent. They cannot be enclosed or privatized without legal process. Now, you might think, surely this medieval law was replaced centuries ago. Actually, no. Parts of the Charter of the Forest remained legally active until 1971. 1971. Humans landed on the moon in 1969, but in 1971, Britain was still operating under legal principles from 1217. The modern framework for common land comes from the Commons Registration Act of 1965, updated in 2006. But here's the crucial part. These modern laws didn't remove the old rights, they just tried to organize them, register them, map them, make them visible. But the registration process was chaotic. Many common lands were never properly registered. Many were registered incorrectly. And the registration itself didn't create the rights, it just documented rights that already existed. Which means there are common land rights out there, legally valid, that nobody knows about. Until someone digs into the historical records and finds them. Let's get back to that developer in England. This isn't a hypothetical. This is based on real cases that happen regularly. The developer does everything right, buys the land from someone who has owned it for decades. The title is clean. The deed shows clear ownership. Planning permission is approved by the local council. Environmental surveys, archaeological surveys, everything checked. Construction begins. Then, someone, usually a local resident, sometimes a local historian, starts digging through records. Parish records, old maps, historical documents. They find a map from 1863 showing that land as common grazing ground, or a document from 1754 recording rights of common. They present this to the council. And suddenly, legally, the developer has a problem. Because if those historical common rights exist, and they do, because they were never formally extinguished, then the land has two layers of ownership. The surface layer, modern property ownership. The shadow layer, common rights from centuries ago. And the shadow layer can override the surface layer. In 2018, a development in Devon was challenged on exactly these grounds. The land had been privately owned since 1872, but historical records showed it was common land before that. The courts had to determine, were those common rights formally extinguished when the land was enclosed in 1872, or did they persist, invisible, for 146 years? The answer? The rights persisted. The development was significantly modified to accommodate those ancient rights. Another case from Yorkshire in 2019. A family tried to build a modest extension on their home. They'd owned the property for 15 years. A neighbor discovered a tithe map from 1840 showing that corner of the property as part of a historic common grazing area. The extension was denied. Not because of planning regulations, not because of neighbor disputes, because of a legal right that predated their ownership by 180 years. These aren't rare edge cases. The Commons Registration Act recorded over 1.2 million acres of common land. But researchers estimate there may be another 500,000 acres that were never registered. Hidden common land, ghost commons, legally valid, just invisible, until someone looks. So the obvious question, why hasn't Parliament just removed this law? Why keep an 800-year-old system that causes so much confusion? The answer is more complicated than you might think. First, common land isn't just a historical curiosity. Much of it is still actively used. Village greens where communities gather. Public footpaths that provide access to countryside. Traditional grazing lands still used by farmers. These spaces are protected because they have genuine public value. They prevent total privatization of the landscape. Second, common land has ecological importance. Many of these areas are ancient grasslands, woodlands, or wetlands, habitats that would be lost if the land could be freely developed. Third, and this is where it gets philosophically interesting, common land represents a different model of ownership, not private property, not state property, but communal rights, shared access. Some legal scholars argue this is worth preserving as a counterbalance to the dominance of private property rights. But here's the real reason the law persists. Removing it is politically difficult. Any change would affect landowners who want more freedom to develop, communities who want to protect access, environmental groups protecting habitats, farmers with traditional grazing rights, developers wanting clear title, historians preserving heritage. Getting all these groups to agree on reform? Nearly impossible. The Law Commission has reviewed common land law multiple times. Each time, they recommend clarifications and updates. Each time, the reforms are either minimal or never fully implemented. So the ghost persists. Not because anyone particularly wants it to, but because nobody can agree on how to make it disappear. So what does this mean for you? If you own property in England or Wales, how do you know if you're affected? First, you can check the official register. The government maintains a register of common land at gov.uk. You can search by location to see registered common land in your area. But, and this is important, the register is not complete. For complete certainty, you'd need to check historical records, county archives, parish records, old maps. This is why property solicitors in England do extensive searches before property transactions. They're not just checking for modern issues, they're checking for ghosts. If you're planning to build, extend, or significantly alter property, your planning application process should reveal any common land issues. Local councils are required to consider this. But here's a tip. Before you even apply for planning permission, talk to longtime local residents. They often know the history of land better than any official record. The good news? For most people, this will never be an issue. Common land disputes are relatively rare. Most common land is obvious and well known. But if you're buying property near village greens, traditional grazing land, or in areas with long historical settlement, do your homework. Ask questions. Check the history. And if you're a developer, this is why you hire specialists. The cost of historical land research is tiny compared to the cost of discovering common rights after construction begins. The ghost of common land. An 800-year-old law that refuses to die. It creates tension between past and present, between communal rights and private property, between historical preservation and modern development. And maybe, just maybe, that tension is valuable. Maybe we need these ghosts, these reminders that land ownership isn't absolute, that communities have claims too, that the past doesn't simply vanish when we build over it. Common land forces us to negotiate with history, to acknowledge that we're not the first people to use this land, and we won't be the last. So when a retired teacher stops a multi-million-pound development with an 800-year-old document, she's not being difficult. She's not stuck in the past. She's enforcing a legal principle that says some things, some places, belong to everyone. And those rights are worth protecting, even if they're invisible, even if they're inconvenient. Because these ghost laws, they're not really ghosts at all. They're history, still alive, still watching. still shaping the world we live in. This has been the King's Ghost Laws. Next time, we'll explore why harming a swan in Britain is technically an act of treason against the crown. If you want to discover more laws from the past that still control the present, subscribe and hit the bell. Until then, stay legal, and maybe check if your garden used to be common grazing land.